Now can you hear?
We're not quite live yet.
Okay.
Yes, I can hear you, Ben.
Good morning, everyone.
We're all set.
Morning, Chris. All right, this is case number 18-20423, CZ Ugansky versus Hadley. And this is a plaintiff's motion to enforce a settlement agreement. This date, I believe, was given back in July. The court just received the documentation to support the motion. And as I understand it, Mr. Barkow was on vacation and would not have seen this documentation, this motion, until really recently. And with that as a preface, Mr. Barkow, if you need additional time to review the matter with your client, or just to gather your thoughts, and you want to submit something in writing, the court would give you that opportunity.
I do appreciate that, Judge. Yes, I was going to seek an adjournment of this matter, as I don't believe I had 9 days notice, and my office did attempt to make contact with my client, and we have not been able to reach him yet. So that really leaves me unable to properly defend this motion, and I think good cause exists for this court to grant an adjournment in this matter, given the timing of the pleadings, my inavailability, and my inability to speak with my client.
All right, Mr. Berry, any issues with that?
Sure. Your Honor, Mr. Barkow and I discussed the matters raised in this motion via email several times. I've attempted to confirm whether or not Mr. Barkow continues to represent Mr. Hadley. We did obtain this hearing date back in July. This was the first available hearing date for Your Honor at the time that we obtained the date. We have attempted to work with Mr. Hadley to remediate the concern, but more fundamentally, for purposes of notice, MCR 2.119C1B provides that at least 7 days before the time set for hearing, this motion was sent via overnight Federal Express, delivered to Mr. Barkow's office 7 days ago. So we have complied. There's no requirement that Mr. Barkow receive 9 days notice. 7 days is sufficient under that court rule. We complied with the court rule. My clients have been anxiously awaiting this hearing and the opportunity to force Mr. Hadley to comply with the obligations that he said he was going to undertake back in January. Now, here we are in September, and really we're faced with the same issues, and this is just more gamesmanship from Mr. Hadley.
Well, the corollary, Your Honor, of the court rule that Mr. Berry is citing is that you have to consent to receive email service, which we have not done.
We sent it via,
still fall under the 9-day window.
We sent a courtesy copy 8 days prior to the hearing on August 31st. 7 days prior, Mr. Barkow received personal service via Federal Express. It was delivered to his office, which constitutes service under 2.107C1 or 2, which is what that court rule permits.
Regardless, Your Honor, I mean, we can arm wrestle over the court rule. I would ask this court's leniency in obtaining an adjournment so I can confer the matter with my client, as I was not in the office and I have not been able to speak with him.
All right, so I am going to give you another date. I mean, if they technically complied with the notice requirement, that's fine. But I'm sure, Mr. Berry, if the shoe was on the other foot, you would want Mr. Barkow to give you at least some time to file a response after you were on vacation and talk with your client before doing a response. So I am going to give him that opportunity. But just so as the court can think about the issues, what exactly is it about the grading that doesn't meet with your client's approval?
Sure. If the
it looks to be grass, it looks to be up to grade, it looks to be sand. What's the problem?
The issue is if the court would take a look at Exhibit 3A.
I'm looking at it right now.
Okay, we're now left with a triangular portion that is not aesthetically consistent with the remainder of the Uganski's property. When we were in court on the on January 17th and placed the settlement agreement on the record, the existing wall, that first wall to the right of Exhibit 3A, to the east of the actual agreed upon boundary line, was to be covered by grass in the grassy area and sand in the beach area. And that was not done. And then more fundamentally, we move into, you can start to see it in Exhibit 3C. There's now a hill that to the west of the boat launch. The boat launch is depicted in that darker colored sand, as we move west to the boundary, and that's also depicted in Exhibit 3D. So that's really the primary issue is good cause exists to remove this wall that was installed on my client's property without their permission while this lawsuit was pending. And Mr. Hadley has now installed a second wall, which he didn't have permission from my clients to do, but my clients won't take issue with. And now they're left with two walls on the western part of their property, neither of which they agreed to, and one of which we need this court's permission before we can remove. And so that's what we're asking. Number one is good cause exists because a significant portion of the western part of the plaintiff's property is no longer consistent with the remainder of the plaintiff's property. You can also see in Exhibit 3B, I believe shows it best, there are birdhouses in the water that the defendant continues to put up despite his recognition of the boundary line depicted in those two. You can see the flagged stakes that show the agreed upon boundary line, and there's a birdhouse to the east. This defendant continues to construct wire fencing along the boulevard area, and it is basically thumbing his nose at the court and at my clients with respect to the agreement that he undertook. So we're asking that the court find that good cause exists to remove the wall and the obstruction that the first wall, and the obstruction that it creates. And
When
also,
you say the first wall, which wall are you
that's the
talking
wall.
about?
That's the wall to the east of the two walls depicted in Exhibit 3A to the right.
Kelly, can you turn that up? Sure.
So the one with like the particle board top on it,
Correct.
that was added after we were in court?
That was added after this lawsuit was filed.
This is the wall that we argued over, correct?
Right. Correct.
Yeah.
And then
Okay, all right.
after we
Okay.
argued over that
All right,
wall.
all right, hang on, I got it. All right, so, so the issues are, there are bird houses that are in the water, which would be your client's riparian property. You take the position that this wall that has the particle board cap on it, for lack of a better word, should have been covered with soil and grass seed. And your other issue is that the sand should cover the wall, I guess, to be consistent, and it shouldn't just drop off within a few feet, that grade should be maintained across the property. Is that right?
Well, I guess with respect to the initial agreement was that a professionally licensed landscaper would provide seed over the wall. The wall would be covered, whether via grass or sand, and that wasn't done. But we have since obtained, and that's set forth in Exhibit 4 the affidavit of Ms. Ugansky, and it shows the erosion that was occurring prior to the installation of additional sand in exhibits 1 through 3 of that affidavit. And also the opinion of a professionally licensed landscaper that erosion is just going to continue. You can add more sand, but it's just going to wash away with the as it rains or the seasons change. And so we submit that in order for this wall to stay, we have to have such a large hill in comparison to the remainder of the Ugansky's beach. We already have to have that because of the new wall that was installed after this settlement agreement, which is the wall to the west of the first wall. And we'd simply ask that the plaintiffs be permitted, good cause exists, to remove the first wall so that they can have the majority of their beach consistent with what it was like prior to the defendant's installation of that wall on their property.
Okay, so that clarifies the issue, and my clerk has another date for us. I think we can do it October, when that was going to be in that 2-week trial.
Yeah. you get back to that. On that Tuesday the 6th, that's pretty full. Let me check on everything.
Already, I just opened the dates.
I know. I'm looking at September 29th, that jury trial you had fell up then. I didn't know if you wanted to open that date back up
29.
of September.
On it.
There was, that jury trial for Larson that just went, so.
Yeah, that's it.
You
Okay.
wanna open that back up?
Yep.
All right, we'll do 1:30.
I hear you.
1:30 on the
1:30?
29th of September.
All right, so we'll be back on September 29th at 1:30.
Will that be, well, I guess the court probably doesn't know yet whether that's via Zoom or in person.
Well, let's just do it by Zoom.
Okay.
Okay.
All right, thanks, guys. That's all for
Honor.
today.
Thank you, Your Honor.